Law professors, by and large, teach Marbury as being about judicial review. I think that's the wrong way to think about Marbury. Marbury, I think, is all about the election of 1800, and you can't understand Marbury if you don't understand the election of 1800. Everybody understands when the Constitution is written that George Washington is going to be the first president. There's widespread consensus about that. In fact, many people think that one of the main reasons so many people were comfortable ratifying the Constitution, so many people were comfortable with the expansive presidential powers in Article 2, is that everybody knew that they would be wielded by Washington, who was as close to sort of the recipient of unanimous acclaim as one could possibly be. After Washington makes the sort of Cincinnatian decision to step down after 2 terms, that's when political partisanship really sort of heats up, especially in American presidential politics. You see it in congressional politics in the mid-1790s, and then with the 1796 election, it really heats up. And of course, Adams wins the 1796 election, and then you have the election of 1800, where the sort of Jeffersonian party really thinks that it has been oppressed by the Adams administration.
In the election of 1800, Thomas Jefferson and the Republicans come to power, and the Federalists, who have been in power for the 1790s, are really mad, and they are upset about losing this election. They think the world is coming to an end, that the Republicans have won this election.
So what the election of 1800 marks is actually the first transition of power in American history. Right? It's the first time, right, because the transition from Washington to Adams is more like a passing of the baton. But then you have Adams, the President of the United States, running against actually the man who had been his own vice president, Thomas Jefferson, and you have the vice president winning, and Adams leaves office. Right? Now, today, that's wholly unremarkable, but you have to remember this was the first time that had happened in the American Republic, and it was one of the few times that had happened in world history. Right? Dynasties don't usually just pass the baton to their enemies without fighting, but they did. But that doesn't mean they were entirely thrilled about it. And so there's a lot of stuff that happens sort of on the way out the door with the Federalists attempting to entrench themselves in power. One of those things is the Judiciary Act of 1801, passed right before the transition to the new Jeffersonian-dominated Congress and President Jefferson. And that the Judiciary Act of 1801 was created actual federal circuit judges. So the 1789 Judiciary Act, as I said, didn't have federal circuit judges. The 1801 Act created circuit judges and allowed Adams to appoint them, so an attempt by the Federalists to entrench themselves in the judiciary. And then there's also another law called the Organic Act for the District of Columbia, because this is right when the federal government is moving to Washington, D.C. And the Organic Act creates all of these Washington, D.C. officials, including D.C. justices of the peace, and again allows Adams to appoint them all on the way out the door. So you get a lot of Federalists appointed to these positions.
And Marbury, of Marbury and Madison, is one of the people who gets a Justice of the Peace Commission. One of the things that makes this case so interesting is that John Marshall, Supreme Court Justice, was Secretary of State during the end years of the Adams administration. And he is the one who is supposed to sign, seal, and deliver these Justice of the Peace commissions. And they get signed and they get sealed, and he doesn't deliver them.
Marbury never receives his commission. This is almost literally late at night on the last night of the Adams administration. The next day, Jefferson comes in with his Secretary of State, James Madison, and Jefferson orders Madison not to deliver the undelivered commissions. And so Marbury then sues. Marbury claims, it is my right to have this commission. I was appointed. It's true it wasn't delivered, but it was literally signed and sealed, but not delivered. And Marbury says that was enough to make me a Justice of the Peace. You have to give me my commission. You have to give me the powers of the office. You have to pay me my salary. And Jefferson, through Madison, says, no, we don't. Marbury sues. He sues directly in the Supreme Court, seeking what's called a writ of mandamus, an order from the court to an executive official requiring them to do something. Now, the executive official who's named in the lawsuit is Secretary of State Madison, but everybody understands that this is really Jefferson's decision. This is the president's decision not to do this. So essentially, if you look behind the sort of captioning of the suit, right, this is sort of William Marbury on behalf of the Federalists suing James Madison on behalf of Thomas Jefferson and the Jeffersonian Republicans.